I have a new comment, Your Honor. It's Mr. Riva Sandoval.
Yeah. Okay.
Judge, I was looking at the DIMS and I have a concern about PC and I wanted to see if maybe we can revisit
Okay,
that.
let's do it. Let me see.
Judge, can I interrupt? I'm sorry.
So, Harold, let me
Yes,
do
sir.
this real quick, let me do this real quick and then I'll hit you up next, Harold.
Yes, sir. All right.
Okay, ready?
Yes, sir.
Tell me.
On October 24, 2022, in Harris County, Texas, an officer responded to an accident involving a pedestrian. Upon arrival, the officer observed a single car in front of a Houston Fire Department fire engine, the defendant standing by. The officer asked the defendant, who is the driver of the vehicle involved in the accident, for identification. The defendant handed the officer what appeared to be a Texas ID card bearing the name of Jose Santos Rivas Sandoval, date of birth January 23rd, 1943.
So it says Jose Santos Rivas Sandoval?
That's correct, John.
Okay.
The officer ran the information on the card through the NCIC TCIC database, trying to do a different name and information. The card easily unglued while holding it, and it was clearly made with paper and lint.
Oh,
So my concern, Judge, is that I get it that if the state is saying that he was in possession of a false ID, it seems like, but I don't see anything in the facts showing his knowledge that the piece of it that he had knowledge of its falsity, which the police officer had to have reasonable suspicion for each element, and there's not one single sentence, not a word that goes to showing that he had knowledge of its falsity. In fact, the DIMS actually go to the contrary, where it says the defendant did not provide a statement about the fictitious ID and only said that it was suspended. If anything, it actually goes in his favor, showing that he believed that it was actually a valid ID. So there's nothing going to its falsity, and therefore it shouldn't be.
you
any
give
probable
someone
cause.
a license and you can kind of peel off the Xerox or what? Does that show knowledge of its falsity? You know, I don't know.
That does, Your Honor. That it's clearly made with paper and lamination as provided to the DIMS. That in itself is circumstantial evidence of the knowledge that the defendant would have had that it was a false ID.
But the statute doesn't talk about any type of circumstantial evidence or constructive knowledge. It says knowledge of falsity.
I know, I'd have to do a deeper dive into this. You know, I don't know.
Don't forget to like the video and subscribe to the channel if you like the content.
In fact,
And now it's like really late. You want to roll it to tomorrow? We can do a deeper dive?
yeah.
Yeah.
Judge, I could do some case law research about it.
For sure.
Knowledge you should.
Yeah.
Thank you, Judge.
Who's the last one?
Last one is Rivas, Judge. He's also in custody. And this is the one I approached DC late, yesterday, because I was pointing late. We're
Okay.
talking about that there was nothing in the DIMS about knowledge, that actual knowledge of falsity.
You have anything?
So what I found is nothing specific. There's been no case law of an item is not enough to provide any type of actual knowledge, at least as prescribed under the statute. The statute controls, the language of the statute controls and explaining.
Ladies, can you take a look?
Yes, sir.
And then I can just take a look and pop with them real quick, and then I guess let me thin the line and then we can explore it further. Okay, can you give me just a couple seconds? Let me thin them out because it's gonna take a little bit longer. Shreya.
Yeah, but I missed that, and then you said that you wanted to.
Yeah, I'll admon.
Yeah.
Okay. Hey,
Hey, Judge.
sorry to keep you waiting.
No, it's just, so I'm just reapproaching again on Rivas, the ID case.
Oh, okay.
So I spoke to the state, and so it seems like we're at disagreements on this. And the argument that I have, Judge, I think I have something that is pretty compelling. There's a case law that I have called Fledging the State, and that's not regarding an ID, it's regarding a check. But the court looks at the element of knowledge in it, and it talks about how possession of that forgery check is not enough to meet knowledge, because mere possession alone is not enough. It's similarly here, by analogy, a possession of this ID is not enough because it would create an absurd result. The purpose of reading the statutes is that the court must interpret it by its ordinary language. And the language says that it has to have knowledge, actual knowledge of its falsity. Now, if for some reason it's ambiguous, then it must be interpreted in a way that doesn't produce an absurd result. So if we interpret it to mean the way the state is interpreting, that mere possession is enough, then it would basically allow the police to arrest anyone that has the ID that has any type of dimple or any ripple or any type of defect in production, because that's essentially that's what's happened here. The police officer's only basis for arrest was that the texture of the ID was wrong or different than what he's.
That's why they do licenses in special ways so that officers know that they're fake or that they're real or fake, right? They have little so they can sit there and they can do this. It's got special colors, special, diagrams on it to be able to ascertain whether it's fake or not. And in this case here, there's a piece of tape and the paper's kind of like coming off.
That's not what I actually read in the DIMS. So the police officer in the DIMS only says that the texture was off. That was not what he was used to. But my point is kind of emphasis on that point that even if it is produced in such a special way, production can still be defective for whatever reason, and that shouldn't subject you to deprivation of liberty.
But at that point, that gives the person the right to investigate more. When something is amiss, right? That's the reasonable suspicion, right? The thing that gives them the authority to investigate further to see, hey, is this legitimate? Because if it was legitimate, then they send them on their way.
Agreed. But it gives the police right to investigate further for that offense, but not reasonable suspicion to arrest. And that's the thing, that the state would need to find that the reasonable suspicion for every element of the offense, and it's the state's burden to produce that. And they haven't produced anything to show that there was reasonable suspicion for the actual knowledge of falsity.
Statement.
So, Your Honor, a couple things. One, this was something that the officer again felt. It's not real. It easily became unglued. The officer's going to be able to testify that, well, this was not something that came from the Texas Department of Motor Vehicles. In fact, the defendant even said, yeah, I don't have a license. Mine's suspended. Lack of knowledge of the law is not a defense.
Right.
Coupling all of
Ignorance
that
is never a defense, right?
And I would argue, Your Honor, we're not saying this is just mere possession. We're not arguing that. We're saying if you take a look at all the facts and circumstances surrounding this case, there is overwhelming evidence that there was intent by the defendant to use that driver's license, because he gave it over to the officers when they responded to the accident. They easily could tell it was fake. It even unglued on scene. So there's enough.
It unglued on scene.
The thing is that I don't see that anywhere in the DIMS of being unglued. And the fact is that
Also noted that this did not have the same texture, was not laminated, or it was laminated, but was not issued by the state. Card easily became unglued while holding it and was clearly made from paper and laminate.
I think that there's enough to go forward.
Okay. All right. Sounds good. All right. Thank you.
For sure.